Good afternoon, and thank you so much for coming today to this training session. My name is Nancy Stuprich, and as I think a lot of you know, I serve as the town attorney for Fort Myers Beach. I work for the Vos Law Firm. We are a statewide firm, and we represent approximately 12 municipalities around the state. And we find that our experience of the different attorneys being in different areas, we learn a lot from our clients, and our clients learn from us as well. So that was one of the reasons for today's training. Today's training, as you can see on the screen, is on the Sunshine Law, public records, voting conflicts, and we're going to throw in a little bit of ethics in there for local government appointed boards, committees, commissions. I think your code has quite a long description of your job titles. With that said, because I mentioned our firm, we do this sunshine training and public records training in our other cities as well, because we're all governed by Florida Constitution as well as Florida statutes. So it's all kind of the same. But when you get into a city, every city or town or village is unique. And sometimes there's some discretion that can be applied in different ways. So hopefully I'll be able to answer any questions you have. We're going to go through the PowerPoint. I strongly encourage you to interrupt me. And it's not going to be considered rude at all. Because unfortunately, I have a tendency to interrupt people. And the reason I do it is I'm not trying to be rude. It's just because I'm so engaged in listening to what they say. And they're saying something, and oh my gosh, I got a question, I need to ask it. And, you know, I'm a little bit older, and if I don't ask it then, I might forget. So I encourage that. We'll just do it kind of in an orderly manner, not everybody at one time. So with that said, let's go ahead and get started. So we have a short PowerPoint presentation. Oh, and I'm the one that controls this.
Will we be able to get copies of this, Nancy?
Sure. And you know why? Because it's a public record.
Do I have to ask Amy for a copy of it?
You just did.
Okay.
You just did, and we're going to be covering that as well. So as I mentioned, first of all, what we're going to cover today is, first of all, our government in the sunshine. It doesn't mean suntan oil. You know, if you go travel out of state and you say, oh, I live in Florida, we have a sunshine law, they're like, what is that? But it is the open meetings law, and so a lot of other states call it that. We're going to go over public records a little bit, talking about voting conflicts, because you do those in your respective committees. And then also the Florida Code of Ethics, just a little overview of it. Before I get started, I do want the disclaimer. I am not knowledgeable about absolutely everything. And the reason for that is because the law is constantly changing. And so coming to trainings like this for you as well as for me is always good. But there are resources out there that can answer questions for you, and they're available on the internet. I first want to acquaint you with this book, which every local government lawyer pretty much carries around in their purse or their bag. This is the Government in the Sunshine Manual, and you can see it's quite thick. It's been developed over the years. It's put out by the Florida Attorney General, and it will go into excruciating detail about the different laws governing sunshine and public records. So whenever a question comes up, this is usually my first source that I go to. So today I told you we're going to do a little bit of ethics as well. So, and we'll talk about it more, but Florida ethics law is governed by the Florida Ethics Commission. And if you go on their website, you can pull this document up, which will give you also a little bit more information about some of the things I'm just going to briefly touch upon. So, with that said, let's get...
Can you say what that document is you just held for all those people out there in DB land?
Sure. This is a document. It's the Florida Commission on Ethics. It's the Guide to Sunshine and the Code of Ethics for Public Officers and Employees. And it has a 2025 date on it, which again, things change constantly. That's why our book is quite thick. I will mention also that sometimes there are court decisions at the circuit court level, which are a little difficult to get sometimes, because they're not as circulated as appellate cases. If it relates to a sunshine or a public records violation or case, you'll be able to find that on the Florida Attorney General's website. So again, that's another good resource to go to look for more information. Okay, so here we go. So what's the general rule? We're going to talk about sunshine law first. This is found in chapter 286 of Florida statutes. So the general rule is that all meetings at which an official act is taken or public business is transacted or discussed has to be open and noticed to the public. And why do we do this? We do this because it provides the public with a right to access government proceedings. It's all about transparency. I'm just going to interrupt myself and say, when in doubt, if you're not sure what to do, go for transparency, because 9 times out of 10, it's the right thing to do. Now, the Sunshine Law does apply to both elected and appointed boards, and we're all appointed here, correct? Okay. So, who does this apply to? Well, it applies to town council because they are our elected body, but also the local planning agency. Anybody here from local planning? Okay, we've got Jim here. And John, okay. And that LPA board, they also serve as the Historic Preservation Board. I think we have some members from the Anchorage Advisory Committee here. Raise your hands. Ooh, quite a number. I think you guys had a meeting earlier. Okay, Audit Committee, anybody here? Okay, BORCAB. Okay, couple. CRAB, which I'm not real familiar with this one. Community Resource. Okay, it's still in your Code of Ordinances. CELCAB. Okay. MRF. And PSC. Okay. Did I miss anybody? Anybody here on another committee that I didn't name? Okay. So it applies to all of you, so I'm glad you're here. So what about if your particular committee created a subcommittee? So you're not one of those named committees, but it's going to be a subcommittee. Does any of your committees have subcommittees right now?
Unofficial.
Hmm.
Well, with the, like
What
our
do you mean
event,
by
our
unofficial?
event planning committee.
Okay,
So
the event
not-
planning.
not
Let's just
everybody
use
can
that as
come.
an example.
Yeah.
So the question then is that event planning committee subject to the sunshine?
Yes.
Yes, absolutely. Why? Because we're looking at the test, whether the committee, or in this case, a subcommittee, is the actual function scrutinized to determine whether it's exercising part of the decision-making function by sorting through options and making recommendations. This says to the governmental body, it would really be back to the committee itself. So what about an ad hoc group that's created by one council member? So I'll pick on the mayor if he's watching. Let's say that he decides he would like to appoint an ad hoc committee to review sprinklers. It just popped in my head. Is that going to be subject to, but he's only one person, and it's not a named committee in your code.
If he appoints people,
If he appoints people and it's part of that decision-making process, because that ad hoc group is going to be sifting through options, perhaps making recommendations back to him that he would then take to the full town council for action. So that is the test. So it applies to any meeting, and here's some words that are bolded, and they're bolded for a reason. I probably should have bolded meeting as well, but it is a meeting. It's the same board when discussing matters that may foreseeably come before the board. So, as I mentioned, sometimes things are not completely black and white, and there's a little bit of discretion. So even these terms could be viewed as being a little bit on the vague side. So if I'm a member of BORCAB, can I talk to a member of the LPA?
Yes.
And the reason why? And it's not Nancy said so. That is the absolute wrong answer. You can ask any town staff member. Why? Because they are two separate boards. Right, okay. So what about if the committee board is acting in a quasi judicial manner? That would be LPA, I believe, that reviews a lot of quasi judicial things. If you are a member of MRF, can you talk to the LPA member about a quasi judicial matter? Yes, you can. And then what's going to happen at that quasi judicial hearing, Jim?
Ex parte communication will be disclosed.
Ex parte communication, there'll be disclosure of supposedly what you talked about, and if that in any way biased or predetermined his decision, he would be disclosing that.
With a chance for cross-examination also.
Correct, by the applicant, because again, it's for transparency, but there's also some due process concerns that come into play. So one of the other words that was bolded was foreseeable. So how do I know what's foreseeable? How do I know what's going to come to my committee? Yes, sir.
I'm sorry, Nancy, can you go back a slide, please?
Mm-hmm.
Maybe one more? I'm sorry, I can't see it. I'll ask it. When you talk about one committee member talking to another committee member, if it doesn't have anything to do with specific issues associated in front of the committee, what if it's a question? What if it's not a question that has anything to do with what's being decided? It's a question about, do I have to disclose that in Sunshine or not? Can I say, can we talk about this without?
So give me an example of your question.
How do we do this? Who do I talk to answer this question?
Excellent.
Who do I forward this information to that's outside the committee?
A staff member, a town staff member, whoever is assisting you with that.
I know that. My question is, does that come under does that have to be disclosed? If I say, Madam Chair,
Disclosed to
if I
who?
say, Madam Chair, who should I give this particular point of information? For example,
But you're doing that in the middle of a public meeting?
no, I'm talking about after the meeting.
So you see him or her outside,
Right,
and you say, who do I give this to?
right,
My recommendation would be that you not have that conversation.
okay.
Um,
So no member-to-member
You
conversation,
should
no
not.
matter what, at any
Anything
time.
about town business, but that's my litmus test.
Right,
Because I've got so many other things to worry about in life. I don't want to worry about a sunshine
Yeah.
thing. And as we go through this presentation, you're going to see that the sunshine law is very broadly interpreted.
right. And I certainly understand, it's very clear if it's anything associated that what's come up in the committee or anything that's going to come up in committee. It's more a procedure question. Who do we say this has to go to?
Staff, to town staff. You should have a town staff member assigned to your committee.
We do, yeah.
And that's the person you would call.
So I would never ask another board member, I would always ask someone outside the board.
Yes.
Okay.
Yes,
gotcha.
and we're going to go a little bit further into that, and I'm glad you brought that up because I'm going to use that as an example as we move forward. So we're talking about foreseeability. So how do we know? How do we know it's going to be foreseeable? I mean, maybe I'm going to pick on my LPA members here. You know, maybe something's going to come before us for rezoning 2 years from now. How am I supposed to know? You have to use your best judgment. The other concern I have with some quasi-judicial things is that sometimes there might be a rehearing. So even after you've had your deliberations in your committee, maybe you're not going to have a zoning, but maybe you talked about something, and then at your next meeting, somebody brings it up again. So it's really not a good idea to talk about something that you talked about at your meeting after the meeting between two of you. Yes,
So,
sir.
so if I say, I can't remember, who said that I'm doing this, or what did we decide I'm supposed to do? I have to go back and watch the,
No,
recording or-
you should call the staff member. That's
Well-
what their job is. They're there to help you.
for example, we're
Mm-hmm.
working on a particular project,
Yes,
okay? And a lot of notes, a lot of stuff going on fast. Hey, did I say I was gonna do that? That can't happen after a meeting or informally?
it might happen, but I would discourage it.
Discourage it.
Again, be safe than sorry, because what's gonna happen is people are gonna see two of you that happen to be on the same committee outside or in a
Communicating.
coffee shop talking and not able to hear what you're actually saying.
So am I
It's a
not,
perception.
am I not able to ask one of my committee meetings to go to dinner with me?
You can, but I would not encourage it. Just because, okay, so best practice, if you intend to do that, I would have other people present at that dinner with you, not just the two of you, have some other people join you who would be able to say that you did not discuss a matter that was foreseeable to come before your board.
Okay, and that can be obviously anyone.
Yeah, yeah.
So, I'm sorry to keep harping on this.
No,
'cause
are
it
you, we're
honestly
learning from
does-
this, aren't we?
It
Okay.
honestly is very hard for me to understand. So if I have dinner with another committee member and my wife is present, that's not on the committee, does she qualify as someone that can say, no, they didn't talk about that?
If she takes an oath, if it becomes an issue and she is cross-examined and is under oath and
Under oath.
attests that that didn't happen. But I will tell you, in a former life, I worked in Escambia County, and we had county commissioners who attended a luncheon, and two of them excused themselves and went outside, had a conversation, and those were prosecuted as sunshine violations. Who is there to refute? I mean, are they both gonna say, yeah, we violated sunshine? They're both gonna say, no, we didn't. But every other person that was at that luncheon was then asked, subpoenaed and under oath had to testify, did you hear what they were talking about? The answer was no in that particular case. Yes,
I guess my understanding, I've spoken to many people that are on committees, the town committees, that say that the condo associations, they follow sunshine laws. However, the committees for town committees are a government entity. And so
Correct.
it's much stricter.
yes.
To follow the sunshine laws. Am I correct?
You are correct. And again, the sunshine law is going to be broadly interpreted to promote the policy of transparency. So when in doubt, just be careful. And again, how do you know what's foreseeable, right? How do you know what's going to come across into your committee? You may know maybe next week, next month, maybe in the next year, but 2 years from now, maybe something came and maybe you had a conversation. We'll see. So that's one of those gray areas. Yes, ma'am.
Well, I would like to offer this up, and maybe this is a best practice, hopefully it's an okay thing to do, but after each of our planning meetings, I've been doing an event recap, which I then send to Curtis, who then sends it to everybody.
Yes.
So that way I have delineated what our responsibilities are, and then if anybody has any questions, if I've gotten something wrong, they can go back to Curtis. I can
Yes.
correct it.
Yes,
It's very
I think that is-
cumbersome, but at least it gets everything out there in writing that I think we've discussed and keeps us moving forward.
That is a best practice to do. Always work through staff. Again, it avoids the appearance of any type of discussion or conversation. And we'll talk more about that as well. So,
And that becomes a public document anyway.
yes,
Yeah, it's
exactly.
searchable because it's
Yeah.
on his,
Yeah.
yeah.
We can go to our council liaisons as well for questions and,
Yes,
okay.
Yes.
Not just staff, but we can go to our liaison council for
Uh,
questions.
I'm saying yes, but now I'm thinking I need to double check, make sure they're not considered ex officios. So we'll
What's
go
that
into
term?
that as
Yeah,
well.
can you define that and quasi judicial?
Yes.
Can ya?
An ex officio person who is a member of your committee, but not really a member. They generally don't have voting rights. That's basically the thumbtail version of it. Quasi judicial is a type of proceeding where a private property rights might be at stake. or the rights of affected parties. And so because of that, quasi-judicial hearings are much more formal than your regular meetings that you have, simply because due process of law, you're not going to interfere with anyone's private property rights kind of haphazardly.
And it's sworn testimony.
Yes. Okay, so moving on. I mean, you guys are like jumping ahead of me. It's a very, very smart group. Okay, so we went to this, we've already gone through this slide. So meetings, what is a meeting? It is in quotation because meeting has several different definitions. It could be a formal meeting like town council meeting, like your various committee meetings, or a workshop, kind of like what we're having today. But also a telephone call can be a meeting, as well as text messages, emails, and other written correspondence that might be going between two individuals, and also informal discussions outside of a public meeting. When we talk about sunshine law, we always use the analogy of, meeting somebody at the grocery store or maybe at church. And, you just happen to be talking and, oh, hey, what did you think about what we talked about? Kind of inadvertently, very innocently, but nevertheless, could subject you to some risk regarding the sunshine law.
I have one more question. Just an example, if someone from my committee were to ask me, hey, what time is our meeting at? Is it okay to answer that, or am I to say, please contact staff?
Well, you could go both ways. I think it would be okay for you to answer that.
Okay.
Why? Because you're not going to debate what time the meeting is going to be, right? Unless that is one of the agenda items, right? That you're going to change the time of your meeting. Is it foreseeable that you're going to be changing the time of your meeting? Probably not. But the easiest way is just call staff. And I do know that staff really likes working with you guys, so give them a call.
Are we gonna talk about Zoom?
A little bit, like remote
Hey,
participation.
I got a brainstorm. I
Okay.
wanna talk to somebody on the committee, just to brainstorm, to see if it's something to bring up. If I do a Zoom and a staff member is a part of Zoom, have I covered myself, or does everything have to be in writing?
No, it could be on Zoom, but there's a whole bunch of caveats associated with that.
Okay.
The question then would be, are you having a meeting? And if you're having a meeting, generally, this would kind of goes into the remote participation as well. You're supposed to have a quorum present to take any type of action, and they
It's
need to be
brainstorming,
physically.
there's no action. It's
So,
like, do
so
you
maybe
think we
it's
should
a-
bring this up or not?
So do you think it's a workshop? Would you characterize it as a workshop?
No.
Because you're brainstorming.
No.
I would not do it. If
Okay.
you're going to do a Zoom meeting, it needs to be inclusive of everyone, because it's two committee members that are talking, and the rest of us, we don't really know what's going on. Okay, you've got the staff member there, but it's still two of you that are already discussing, and you're not being transparent.
What if the Zoom meeting was recorded?
No, I don't think it makes any difference.
Okay.
When you say transparent, you mean not only transparent to the other members of the board, but transparent to the public?
Absolutely. Transparent to everyone. This is the beauty of local government.
Does it apply to a condo board meeting?
No.
Nothing.
No, those are different rules. Yeah, this is under chapter 286.
Uh-huh.
I am not saying anything today about condo rules.
Perfect, okay.
718, there you go. Okay.
718.
By the way, would you clarify the difference between a board and a committee in terms of the sheer definition?
Yeah.
Because I've heard it used interchangeably. Is there
It's,
some clear, because we are advisory boards, not committees. What's the
I
difference?
don't think there's a real distinction between them. I think it's just the way that your code identifies you. Regardless of which one you are, you're going to be subject to this stuff. And, also your code talks about commissions, and I don't even think the town has a commission anymore, but the word commission is there, so
Yeah.
we kind of go along with that.
To your point, Barbara, I've wondered why there is no consistency in the naming of the different things that are advisory to the town. I mean, some are committees, some are advisory boards, they do the same sort of thing, but there's just no consistency in the nomenclature, which
Sometimes
think
it's
it's
just a drafting thing, and
Yeah.
over time, you know, somebody drafts something really quick and it goes forward and whatever. Okay, so how do you comply with the Sunshine Law? So there's really only 3 things you've got to do as far as procedure. Your meeting must be open to the public. Are we open to the public right now? Yes, we are. We have seats available. If anyone were to come in, they would be guided to this meeting. You have to have reasonable notice of the meeting, and it's usually 48 hours, because honestly, for our elected town council, sometimes things come up and we have to move very quickly. Unfortunately, sometimes it's during that hurricane season. We try to give the 48 hours, but under the circumstances, it might be less. If we can give more, we like to do that as well. You need to take minutes of your meeting. So even if you had, let's say hypothetically, you had a ad hoc committee composed of 3 people, and you met here at Town Hall, you gave notice of the meeting, you still need to take minutes of that. The one thing I do want to add is that your minutes do not have to be verbatim. A lot of times you will see that in quasi-judicial matters, they do have a court reporter there. That's fine. But the official minutes are what the town produces, and then at your subsequent meeting, you need to approve your minutes for that. So, but I only make recommendations. So does the sunshine apply to me? Yes. Advisory boards, committees, commissions that are created, you are subject to the sunshine law, even though it's only a recommendation and you're not the final decision maker. And the reason for that, the why, is because you are part of the decision-making process. The decision-making process for some of the topics that you all discuss starts with you and then works its way through the process. Okay, so while I've really been promoting staff, and they didn't pay me to do that. While a board member is prohibited from discussing board business with staff, is not prohibited, you can't use them as a liaison to find out what another board member is talking about. And the example I give is it looks like a typo there. A board member can't ask staff to poll the other board members to determine their views. Like, hey, what do you think? You think I'm right? You think I'm gonna be like the only person that's not voting for this? And you typically will get the answer of, I don't know, even though they may know, but they're not gonna encourage and tell you what others. So in the way, we're almost like priests in a way. We're in the confessional and we might hear a couple things and maybe we know which way that vote's gonna go just because we've had individual conversations, but we never ever disclose what you have shared with us, because that would be a violation of the Sunshine Law and you would be serving as a conduit. Now, what about if it's not a staff person and maybe it's a spouse? Maybe you share your vote with a spouse and then one of their friends who also happens to be on your committee calls and says, hey, George, what do you think? Can't do that either. So meetings, back to meetings. So the location has to be accessible to the public, which is just like our meeting room today. When we get our new town hall, there's going to be so much more space. So you guys will be really happy about that. It must be adequate size. So you can't really have a meeting in a really cramped corner because it tends to discourage participation. And again, you want people to come to your meetings. That's one of the purposes of having open meetings. So adequate size. You can't discriminate against or restrict the access to the public. For instance, the next bullet is the example of that. If you have a meeting in your private home, is that open to the public? No. You can't allow some people in and some people not. So then it raises the question of restaurants, and we always talk about this because, especially here on the island, you know, restaurants have space, right? And you could have a meeting there. But the problem is that the case law and the Attorney General, they've determined that having a public meeting in a restaurant might make that person from the public that's there feel like they have to buy something. And maybe you don't have a lot of money and you can't really, you know, you don't want to go and have to buy a $20 meal or something. That might prohibit you from, or restrict you from going to that meeting, and that would not be permissible. So now we've got, how about site visits with town staff? Any comments about that? Do you think that if you're getting a new swimming pool, right? Maybe you guys decide you want to go over there and visit what repairs are needed at the swimming pool. Collectively, could you walk over there with town staff?
Only if you noticed it.
Only if you noticed it, and it's really discouraged to do that. It used to be okay, but it's just too suspect that there could be some conversation about the repairs that will be being made, coming to your committee for an opinion or recommendation. Now, my last one, what about if Beach Talk Radio goes? Because they're the media, right? Still not enough under the case of Finch versus Seminole County and School Board. And the reason is because they are one media source, and there are other media sources, and it still doesn't open it up to the general public to go. So I discourage site visits. I also, you know, in the quasi-judicial ones, it's really hard because a picture says 1,000 words, right? And a site visit is 1,000 pictures because it's a complete different perspective of something that's just on a piece of paper and something that is three-dimensional.
Point of clarification.
Mm-hmm.
So if we are not going to a site visit, or it happens to be something that's, say, on the street that we live on, and so we're just incredibly knowledgeable about site specifics.
Mm-hmm.
If we are not with any other board member,
Mm-hmm.
and potentially with either developer or residential owner or whomever it may be,
Can you go?
then we go.
Sure.
That's what I thought, as long
Yeah,
as we're
so
not
my
with
question
somebody
is
else.
really a
The
site
one-on-one.
visit by the committee.
Right.
I'm sorry, I
just
should.
wanted that clarification.
No, that is correct. But then, you know what happens. When you get to the
Yeah.
meeting, you
You disclose.
disclose it, right? And sometimes attorneys will say, oh, so you visited the site, and when were you there? Oh, you were there on Friday, because the big flooding event was Sunday. So walking away from that site, you viewed something that was very dry, yet the condition changed. So by doing these site visits, you get information and knowledge that everybody else doesn't have. So my recommendation is if you do an individual site visit, that you share with the group what you actually observed. It would not be a sunshine violation because there is not another member present. And when I say share it with the group, share it in public, at a public meeting. Okay, so meetings. So you can adopt the reasonable rules because basically your meetings need to be orderly and professional. And the Sunshine Law does not allow boards to say to ban non-disruptive videotaping, tape recording, or photography. So it is a public meeting, and if someone brings in this type of equipment, they can hear with their own ears. So the fact that they're tape recording it or they're videotaping it because they can see you, or they're taking a photograph, really makes no difference because it is a public meeting. So there's, how would we say, a newer section. It was back in 2013, which isn't so new anymore. But, so members of the public should be given or shall be given a reasonable opportunity to be heard on a proposition that is before you. And in town council, it's basically the 3-minute rule, but this does vary, and I'm sure you've seen it in action depending on the circumstances. As a body, you guys could vote to more. I discourage less, but sometimes it's important. Sometimes it's not important, but sometimes you have to do less just because there's so many people there. But it has to be reasonable, a reasonable opportunity to be heard. But there's always a but, right? Always an exception. The opportunity doesn't have to happen at that meeting as long as it happens, or if there is an opportunity during the decision-making process. And, you know, if you can have that public comment at your meeting, I would encourage you to go ahead and have it, because being broadly construed, opening it up, transparency, it's not a bad idea. However, if someone made public comment at a prior meeting and they don't really have anything else to say that's different, you know, you could still afford them the opportunity, but they're going to repeat. As long as they had the opportunity to say it at least one time in the process, it's fine. I would prefer not to have to argue that, and just welcome the public, welcome these public comments. And then, again, it should be in reasonable proximity and time. So if someone made a comment a year ago, you probably want to afford them that opportunity to speak again. Okay, so again, orderly conduct or proper decorum. And sometimes things can get out of hand, but you are not restricted under sunshine for allowing inappropriate conduct and you know, disruptive public meetings. Okay, so how does this work? So generally, there's rules and policies that you'll come up with. Your rules and policies, you should have time limits that are basically your starting point, with the opportunity to deviate from those based on the matter that's at hand. Sometimes when there's a large group that's promoting a particular viewpoint, you may ask to have a representative appointed, and then that individual would speak for the whole group. You've probably seen this in action where, you know, everybody gets their 3 minutes, but they're going to pass 2 of their 3 minutes to someone else so they can have 5 minutes in that process. And then sometimes they don't even end up using the 5 minutes, but whatever. Procedures or forms. We like to do that, and generally it's the Amy, the town clerk, who will have those speaker forms. I'll laugh. Those speaker forms available. We don't do that as an impediment to discourage people, because some people don't really want to say their names. However, we do that for purposes of record keeping and having accurate minutes as to who spoke and who didn't. A designated period of time for public comments. You can have public comment at the beginning and at the end, or just at the beginning or just at the end. It just depends on your committee's preference. But my perspective is as much public comment as possible is always good. So now we're talking about penalties. So there is a distinction here. So in the event that there is knowledge and you know you're not supposed to be doing this, you know you're not supposed to be talking to another member of your committee about the agenda matter that's coming up next week, you're knowingly violating the Sunshine Law, and that is a misdemeanor of the 2nd degree. But if you inadvertently violate the Sunshine Law, it could result in a civil penalty as opposed to a criminal penalty of up to $500. In any of these situations, there's going to be a prosecution, and those are not fun. They will take away a lot of joy from you. So the Sunshine Law provides that no resolution, rule shall be considered binding unless it is taken at an open meeting. So even though you may have a violation of the sunshine law, it's not just your problem and the other person who you violated it with. It does have an impact on the community, and that is that there's no decision that's been made. You will have to have a do-over, and there's going to be a delay. Because, well, first of all, let me ask the last question. Who enforces the sunshine law? Is it me? No. Is it Amy, our town clerk? Is it our town manager? It is the state attorney who enforces the sunshine law. So if there is a sunshine law violation, it will be initially prosecuted as a criminal offense. And the state attorney, the investigators will come. They will ask for all kinds of information. Who were you with? What did you see? Who did you hear? Again, it's not a situation that you want to find yourselves in. Okay, so I talked a little bit about, the no decision, the do-over, and the delay. So because it shouldn't be, the sunshine law can't be used to evade, the transparency of open government. Anything that happens that is the result of a sunshine law violation is ab initio. And what that means is it never, ever happened. And that can have consequences. My last slide, again, I kind of like this slide, that there's no decision. And a lot of times you need a decision on certain issues because there's a lot of anxiety. It's like, can't we just get this over with? We need to get a decision done. So now whatever decision was done is now wiped out. You got to do it again. All the noticing, all the individuals coming before you, and then the delay of the process of the project. And let's say hypothetically that there was a sunshine violation related to a grant that had a deadline, and now you've got to go back and do it over, and that deadline is now passed. So there could be financial consequences as well associated with that. Now I got questions for you. So if you've been paying attention, you should pretty much know the answer to these, although some of them still are kind of in that gray area. So a staff member has conversations with several committee members, and the last member says, will I be the lone vote if I say no? Do others really think we need another, you can fill in the blank. Is that a sunshine violation?
Yes.
Yes.
Yeah, because you're trying to use that staff member as a conduit, right? So we're not going to do that. How about if a member creates a newsletter, or it could be an article, a blog, a Facebook page, a Twitter post, and he says that I intend to vote yes at the meeting. And then, of course, another member says, well, if you put that in the newsletter or in the article, I'm going to do my own. And then they do it. And they say how they're going to vote. And then a third member does the same. Do we have a sunshine violation?
Probably.
Maybe not.
This is a gray area. And the reason it's a gray area is because has there been interaction between those two members? I'm posting my opinion, but then do we even need to have a meeting? Let's say we have a committee of 5 and everybody posts what they think, do we even need to have a meeting?
Yes.
Yes, we need to have a meeting, absolutely. And then at that meeting, there's going to be dialogue between the committee members, and there could be questions as to, well, why did you feel that way, and that kind of thing. You kind of want your views to be known, but I try to discourage that.
So, I'm sorry, I don't mean to interrupt you.
No,
So if
go ahead.
a member of a committee were to go on a social media and talk about something that's an upcoming vote in a committee that, and they're talking about which way they're going to vote or move a motion, is that what you're discussing as well?
That's what I'm discussing. There is a distinction if the meeting is quasi-judicial or if it is just a meeting that you're having. If it is quasi-judicial, I put put up red flags and I ask for caution to be held, because our quasi-judicial decision makers, they come to that meeting and they must decide only based on the evidence and the testimony that's given to them. They can't come to the meeting with a predetermined view or vote. And if you've watched some of our meetings, you will see that after they make some disclosures, or if something's brought to everyone's attention that, hey, they were on this media or whatever, and they said this, we ask that question, and then the property owner's attorney, they can delve further to see if they really have already made their mind up, or if they're open. I mean, sometimes you might think a certain way, and then you come to the meeting and you hear the dialogue and the discussion among others, and it changes your mind. So I caution that. Facebook and Twitter and all our social media, they're good social media, but when you overlay local government issues and matters, it can become very tricky. And so on your personal pages, I would ask that you try to avoid saying anything about your public role and the things that you're involved in.
So, I'd like to ask a question. So I posted about Cruiser Appreciation Day coming up and basically said, I encourage you all to attend, and reposted something that the town had put out. Is that a bad thing to do?
So the only concern I have is you may have some other friends that are on your committee, and then let's say one of your other committee members is one of your friends, sees your post and then replies, yes, I think it's a great idea too, and I'm going, hope to see you. That could become problematic because it's two members of the same committee posting. The Sunshine Law is not easy. It's not, and neither is public records, which we'll get into as well. Yes, sir.
So I see that, I'm just gonna
Yeah.
add here, I mean, a lot of council people will repost something that the town has put out on their town council Facebook page. That's not appropriate either?
So, no, when you think about posting and articles and all of that, it's a one-way communication. It's when you have the interaction that becomes problematic. So
So don't
just-
like my post, don't comment. Just repost.
You could refer them to the town's
Okay.
website or social media page, which would have some information on it as well. Yes, sir.
So while we're on, excuse me, Cruiser Appreciation Day,
Yeah.
we have several tables from several charitable organizations. We also have some advisory committees. I know the Murph table was planning on being there, setting up, giving out turtle information, other information for the general public. If I'm listening to you correctly, only one person should be at that table
From that board, yes.
from that board.
Or you have other people there as well that can attest that they are not talking about something that's foreseeable to come before their committee.
Okay.
Correct.
So can Anchorage talk to Murph?
Yes,
Yes. Why?
Because we're not on the
two
same
different
committee.
You're not on the
boards.
same boards, right? Okay.
Okay, thank you.
But two Murph members at a table.
Should have a third person there. That would be my best practice. And the other thing is, I think Amy and Jason, they've probably already taken care of you. We do like to put a disclaimer on when there's an event where multiple people from the same committee, board, commission, council, agency, when they're going to be in attendance, we will go ahead and post that they will be in attendance. So that way, for instance, today, any member of the public could come and know that more than one member of the advisory committee is here today. And then there would just be a little bit of follow-up at your next meeting to document that more than one of you were here today.
Yes, and in the past, I've been doing the Murph pop-ups, and we have had more than one Murph member. But our practice is that if someone were to come up and discuss something with the two of us, in regards to anything in regards to Murph, that we
Separate.
separate, one of us would walk away, and that's how we've conducted
That is
ourselves.
excellent.
Thank
That
you.
is another strategy to implement.
Thank you.
Now I
Okay.
understand when I always thought you were being rude.
I have a question.
Yes, go ahead.
Okay, so Nancy, you talked about the ad hoc committees and you talked about a subcommittee, but have you talked about, or will you talk about a Friends organization, which is a separate nonprofit organization that also has the same mission pretty much as CELCAP?
So they're,
This is the situation that we have
Yes.
with two advisory boards, one with the Mount House and the other with Bay Oaks.
I know that that is a very sensitive topic, and I think we could probably have some conversation outside of our training. But if you apply the basic formula, or locally we've been calling everything recipes, the formula is what? 2 or more members of the same committee. So if you have 2 members of MRF or BORCAB or whatever other committee might be at play, who also serve on another board, are they talking about MRF business? It seems like the content or the mission of that other board is something that would be discussed there. So we need to come up with a solution for that.
Okay, so you're
I am
you've not
discouraging
ironed
it.
that out, is what I'm hearing, right?
No, well-
Do we get a special then meeting after this meeting?
You and I
to
can
go
talk
into-
more about it. I
Okay.
think we've had a little bit of conversation, but we didn't close that loop, if I remember right. Okay, so
And
let,
on that, it just sparked another thought that I
Uh-huh.
had specifically. So we're Public Safety Committee that I'm in. There's also other nonprofit agencies kind of doing their own thing. Makes it challenging, and I probably know the answer, but it makes it challenging for us to do our role because we can't get together, but this committee that's not part of, could basically meet, do a whole bunch of things, present it back to the town council or go to Lee County and do a whole bunch of work and they don't follow the Sunshine Law. So it's almost
That's
like a
correct.
competing agency and makes it, actually, for us to trying to do the work, it feels like we're in quicksand. And they're just running around doing whatever they want because they don't have to follow the Sunshine Law.
no, and that is, I understand that. And one of my big peeves is the fact that the Florida legislature is not subject to the Sunshine Law. They drafted it, they adopted it, but they excluded themselves from it. So you
Convenient.
have
But of
conversations going on all the time. So the way I would address that is, I think you can have multiple meetings of your committee. You just have to notice it. It has to be in a public place, right?
Yeah.
You have to take minutes. You can meet
Sorry,
often.
Amy.
I know, they're gonna have my back. They're gonna. The LPA is having a second meeting this month as well, just because of their workload, and it's okay to do that. And that's how you can have that dialogue with your members in the sunshine.
Okay.
I just wanted to clarify one more thing. If 2 members from different committees, boards can meet for lunch and discuss things that are happening on each committee, is that
Yes.
okay?
That's fine.
Okay.
That's fine. Okay, so here's my question. You're attending a training and other members are present. You ask a question and so does another member of your committee. Oh my gosh, that's already happened. Is that a sunshine violation? Did we violate sunshine today? No, because we're in a public meeting and we've noticed it, and there'll be some minutes, I think, for your respective committees that you guys were here and we participated. Okay, now, this one's a little difficult, but we've already talked about it. So you observe 2 members of the same committee, that's part of the formula, right? Talking in a corner, but you can't hear what they're saying. So is this a sunshine violation?
No.
Not necessarily.
Maybe. It's gray.
Right.
It's a perception issue.
It's a perception issue, and what is the best practice?
No.
Well, not to do it, it's have a third person, multiple people there. Now, when we talk about the third person, you may want to have somebody who might not be biased. So a spouse might be biased, because she probably wouldn't want her husband or spouse or wife, whatever, having a spouse there, because you don't want the other spouse to get in trouble for sunshine. But you know, one or two people just hanging around, say, hey, you know, they're here. You know, sometimes what happens is, I know you all, when you leave today, you're gonna be knowledgeable of these things, but maybe somebody who didn't have the opportunity to attend might not be knowledgeable of the Sunshine Law, and we're gonna have another slide in a minute. Maybe they just got appointed and they just don't really know, and so then they come up to you and go, hey, my first meeting's coming up, what do I need to do? Can you tell me, how should I vote on this? What do you do? Hey, look, I can't tell you what to do there because there's something called the Sunshine Law, and I don't wanna violate it, and I don't want you to violate it, so I'm not gonna answer you. It's not because I'm a mean person, but, that's the reason why, but I suggest you call staff, and staff will give you more information. So try to distance yourself from it. And then if they keep running after you, but I really need to know, and I can't call staff, again, take that conduct. Because if somebody does say, well, I saw them, they were running after each other and everything, you know, you can testify honestly that, yeah, she was asking me, but I didn't respond, and I kept telling her, we can't talk about this.
What if you did respond?
Did you know better? I mean, is that an oops, unintentional, or is that an intentional?
Is that at a point when you realize that it was a mistake that you did it, and it's a mistake that you then contact someone in staff and just let them know that this was
Yes,
discussed? Or-
again, remember the slide that talks about intentional? That's where the criminality comes into play. An oops or an unintentional could have a civil penalty, but, you know, there's a lot of things that
So
happen.
how would we rectify it if we
I
realized that that had happened?
don't think you can. I mean, it's done. You just maybe hope and pray that nobody else heard you or says anything about it, but it's unintentional is
That's
the point.
hypothetical, by the way.
Of course, absolutely. All right, so I think we've gotten this one down. Okay, you're invited to a tour of the new town hall along with other members of your committee. Can you go?
No.
This one is also kind of gray because town hall is a public place. And you could say that members of your committee, I'll use Anchorage. Anchorage committee is meeting at the new town hall for whatever reason, and notice it, have minutes, you're fine. But again, if you comply, that would be the best practice.
Amazing.
Yes, sir.
And maybe it's a little bit of a follow-up of what Jan was saying. So the Anchorage Committee is having the Cruisers Appreciation Day.
Yes.
So there'll be a lot of people from the committee
Mhm.
there. We'll be interacting and talking to each other, and how's that fall in this whole sunshine thing?
Well, are you going to be talking about something that you foreseeably will be talking about at the meeting? If you're going to be talking about how to plan for a bigger event in the future year, I would probably not talk about that.
So,
I might talk about like that nice boat over there. Or
Right.
did you talk to Joe,
Right.
who's been around the world?
but if, okay, we're doing this, and
Uh-huh.
we say, that isn't really working, we gotta do this different next year.
You know, I hear what you're saying, and it is very frustrating, especially because we're such a small community. I think the issue here is when you plan, when an advisory board, which is a government advisory board, will plan social occasions that would encourage that kind of camaraderie, it sets up a red flag. Again, with the issue of perception. So when we're looking at forming the Friends of Bay Oaks, they're the ones that are in charge of doing social events or fundraising events, just like Friends of the Mound House. That's the role that they play as advocates for the Mound House to entertain those
Members.
principles of getting
Mhm.
support and advocacy for the Mound House. But with regard to CELCAB, we don't do any of that. There's a very clear delineation as to what our role is that's been established by ordinance.
Mhm.
And that's the only role we play. We do not do social events. That's the Friends of the Mound House that does that. So I think that division is so much clearer.
It is, I mean, we don't have a Friends of the Morningfield, so, I mean, we are what
So-
we are.
Right. but
And so, I
then-
mean, as long as we talk about, hand out the ticket, I think maybe we're okay, but if we talk about, you know, the event itself, I think we can,
If it's
hopefully we can
foreseeable.
solve issues
Right.
while we're there.
Well, you can observe and then you can discuss them at your next meeting.
Right, how to do
You
it
can,
better.
right, kind of information gathering.
Yes, but I mean, in the heat of the moment, if something isn't going well, I think we have to
I don't
figure
know
it
if
out.
the
or
state
somebody-
attorney's there, you know.
And I also think that if someone from the Morningfield were to come up and ask about, discussing some, form of the Morningfield, that, we just walk away and one of
Exactly,
us
right.
can have a discussion with the Morningfield guest
Yeah.
and the rest of us can walk away from it.
And bring it back to the meeting and discuss it then. Okay. Yes, yes, always
I've
that
never
disclaimer.
been-
It's perception, perception. I'm sorry, what
No.
is CCAP? I've heard this.
Cell cab.
It's okay.
So
It's
that's
okay.
a Mound House.
Oh.
It's the Cultural and Advisory Board for Mound House and Newton Park. Because that's the historic,
Thank you.
structure.
Okay, so here's kind of a similar question. You're invited to a tour of a new development project along with some other members of your committee to see the donation of artwork or roadway, playground equipment. Can you go? Really? Why would
As
you go?
long as you're not discussing anything, it's a new development, you didn't say what the development was. If you're seen in public, you have other people there, it's a new development.
I
You
mean,
know,
is it just
if
for
you're
your
going to the-
committee or public?
if you're going to the library and you're watching the library open and you find other people from your committee there, as long as you're there looking at the library, it's
And you're not
reopening,
interacting. Okay,
and
so
you're
you
not
got a
interacting.
couple of factors that you're throwing in there. So kind of maybe a private event where it just happens that two of you are there, but you're not interacting, but you just both go to the library event. The other alternative would be to talk to staff and have staff post it that two or more members of the Anchorage Committee would be present and may participate. So, okay. All right, here we go. So you're newly appointed, I think I gave you the answer to this one, as an ex officio officer to a committee. You don't vote, and you haven't been to a meeting, are you subject to the Sunshine Law? The answer is yes. Because you are ex officio, you are still subject to Sunshine Law, and the fact that you haven't been to your committee meeting yet and been sworn in, you still have been appointed. So the minute you get appointed, the Sunshine Law and Public Records Law will kick into effect.
What if
Speaking-
you've never been briefed on or trained on the Sunshine Law, or even know it exists?
Well, I think
Ignorance
you
is
signed
not-
something when you
Yeah.
are
No
appointed, right?
excuse.
I think you
Yeah.
do, but part of the onboarding for going into the committee
Right.
should include a discussion of that. I haven't
Right,
really been
Who's
a
responsible for that?
staff. Staff does a lot of things. They're gonna hate me.
We did,
You need a neutral person.
we did way back
I understand.
Did we sign?
I just,
2
If
years
you,
ago.
once you're appointed, then fill
I
out
wanna
the
bring up any
application.
particulars, but I can envision someone serving for more than 1 year
Without having
Committee.
training?
and have never been briefed, have never been, trained, and quite frankly, been ignorant of
So
such
maybe
parameters.
I'm gonna play devil's advocate a little. So maybe at your next meeting, with your other members there, you discuss what you've talked about today and suggest that individuals attend, a sunshine meeting.
That's an excellent idea, and I think that probably should be something that committee chairs should be responsible for making sure it happens. But what if it happened in the past?
Yeah, is that something that maybe as you're on a committee, you have to sign each year that you're knowledgeable of sunshine training or that you've been through it? Is that something that is
I don't
necessary?
know. You know,
for
I've run a
tracking,
couple
or-
stop signs in my life.
Yeah, That's a hard stop. Okay.
You know, things happen.
Okay.
Let's go on to the public records law. This one will be fun too. Okay, so again, transparency is important, right? And you have to have a right of access to the records, as well, local government, as well as to private entities that are acting on their behalf. Which means all these companies that contract with the town, when we draft their contract, they have a big provision in there that talks about, you know, by contracting with the town, we can come to you and ask for part of your records if there's a public records request. So this public records accessibility is in your Florida Constitution as well as in the statute. So this is serious. And the only exceptions to the disclosure requirements for public records are those that are established in Chapter 119 or in the Florida Constitution. So, for instance, when you applied to be appointed to a committee, board, or commission, do you remember being asked about whether you qualify for a public records exemption, such as maybe your email, your address? See, I was told you were.
It's a button you check on your
Yeah.
application.
Yes.
Okay.
Oh, of course, of course.
Fine-
Okay.
It's in the
Yes.
fine print.
What if we didn't know what the heck
Thank,
that meant?
thank you, Amy.
Yes,
I'll answer yes.
yes, yes.
So what are public records? Oh my gosh, there's an entire paragraph. I mean, a public record could be a sticky note, a document, a paper, letters, maps, books, tapes, software, film, sound recordings. The ones that become problematic are text messages as well as voice messages. If you try to call me, you cannot leave a voice message because I do not accept voice messages, because then they are public records, and in the event someone makes a public records request, I have nothing because I do not accept voicemail. So the Florida Supreme Court, just like the Sunshine Law, it's a very broad interpretation. So the public record, the document, the text, the whatever, it has to be intended to perpetuate, communicate, or formalize knowledge. And that's between two people. If you take your personal notes, as I see or your chair is doing, as long as she doesn't share that, her personal notes, her scribbling, as long as she doesn't share that with another member, she's okay, because that's just personal to her. She hasn't communicated, she hasn't formalized her position on something and shared it. But drafts, if there's a draft that's floating around, you're going to say, well, that isn't the final document, but it has been shared and it does have information on it. So that is a public record. So the learning is, regardless of whether it is in final form, is open to public inspection unless there's an exemption. This is the one that Becky always cautions us about. And Becky is my boss, Becky Vos. There is no, this is really embarrassing, exemption from the Florida records law. So, you know, sometimes when you're behind that computer or if you're on your phone, you don't have like everybody looking at you. And so sometimes you tend to write things that maybe you wouldn't normally write because that person is not standing there right in front of you, right? But that is a public record if you hit that send button. So you need to caution yourselves on that. The other thing I want to mention real quick, I'm just going to throw it in here, is the difference between reply all and reply. Oh, good. Some of you have learned about those two culprits, right? So always be careful before you hit that send button. If you are intending only to reply to the person who sent it to you, which of course is not one of your members, right? Your committee members, that you only send it to them, reply. Do not do reply all, because Jim does a reply all saying his position. John does a reply all sending his position. Now they know about it, each other, and now there's a perception that could be discussion between them and a public records, and we don't wanna go there.
Nancy, you touched on text messaging. Is text messages considered public record?
Yes. If it deals with public, work and information. So, it's really tricky, because let's say I have a text message to, a friend of mine that says, hey, I'm gonna meet you for dinner at Pinchers. I have to finish this report on, public records law because I'm doing a presentation on Tuesday. So part of that text message is public, the part that I'm talking about, the presentation that we're doing today. But the fact I'm going to Pinchers to meet my friend there, that's not public. So text messages can be very tricky. If it relates to public business, it's public. So we got through the embarrassing one. All right, emails.
Talking about passing a note during a meeting too, Nancy, would you?
Yes, we had a situation in another city where a very contentious meeting, and two elected officials were seen on video, because all our meetings are video. This is being videotaped today. And there was a sticky note that got passed from one to the other, and somebody saw it. And so there was a request made as a public records request for the sticky note that was passed during the meeting, as shown in the video at this time on the video. Okay, so now we gotta find the sticky note, and unfortunately the sticky note never was found. But it shows that, you know, that is a public record, people are watching, so be knowledgeable of public records law, and don't find yourself in that situation. Now, if that sticky note just went into my book, and my book is my book, this is my personal notes. But the fact that it was given to someone else, it perpetuated, communicated, those are the three magical words. So, okay, let's move on. The first bullet, thing up here is basically to tell you that, it doesn't matter if the device that the public record is created on is public or private. So I could have public records on my phone. I could have public records on my private computer. And those of you that do only committee work, it might be in your best interest, I think it's been suggested as a best practice, to just create a email address for you as Anchorage Committee. And so every correspondence related to your duties on the volunteer board goes to that email. So if there's ever a public records request, you just take that entire email and give it to the town. Makes it quite easy. So anything that's on an agency's Facebook page is subject to public records. And then it raises the question of your private Facebook page, which I think we talked about. If it relates to public business, it's public record. So, so Florida statute says that if you have in your possession a public record, it has to be inspected, copied by any person desired at a reasonable time, under reasonable conditions, the supervision of the custodian of public records or the custodian's designee. So how does this work? There's a public records request is received by the town's custodian of records. Who is that? Good, excellent. And what should you do if you receive a public records request?
Give it to Amy.
Okay, and does it have to be in writing?
Yes, I think it does.
I think so.
The question is not well worded. It would be, did the request have to be in writing to you that was made? So as the Anchorage Committee, if I saw you at a meeting and I said, hey, do you think you could give me a can I get a copy of your management plan?
I think it needs to be written. It has to be in
I think it is.
No, it can be oral. It can be oral. And then you would call Amy and you would say, hey, Nancy asked me for a copy of your management plan. Can you give one to her? And then she would follow up on that.
ton of questions.
I just tell her to call Amy, ask Amy about it.
You could do that, but,
That's a your position, since you don't have anything in writing, you're not-
so Amy, I think you should come to the podium. And maybe you can run through the rest of the slides.
Oh.
So, as for the oral, they can ask you, you just have to acknowledge that you've received this record from, you're gonna pass it on to the public records custodian with the town. And then I'm gonna ask you a ton of questions, how am I supposed to get this to this person? Am I, did they give you an email address, a phone number, how do I get in touch with this person? You can't make them tell you that information? So I may create a public record that I just have sitting here, hoping someday somebody's gonna walk in and pick up. Cause I don't know how to get it to that person, so, it doesn't have to be in writing, they can give it to you orally. You just have to acknowledge that you've gotten it and you're gonna pass it on to the right person.
So it would behoove us to ask the question of how do they want to receive it?
Yes, but you can't make them give you that information.
Gotcha.
So, okay, so I don't know where we're at on this slide.
We're on number 2.
Okay, the town will search its records and ask you to provide any information you may have on a private device. Like in your instance, if somebody asked me for a public record, that something happened in your or your private emails, I'm gonna reach out to you, more than likely by phone or by email, probably by phone, and say, Chris, I have received a public record for this subject, do you have any emails about it? And you are either gonna say, yes, I'll send them to you, or no, I don't, and that would form my response back to the requester. Your private emails are not private in the case of town business. I just don't have access to them. I have to depend on you to give them to me.
But as long as we send an email to staff that's got the FMB,
Anything that
then
comes
it's-
in that
it's
goes
co-
to @fmb.
So I don't have to worry about that is what I'm saying, cause it's already public record.
Right, where you're capturing everything that comes
Okay.
through us.
Thank you.
To Nancy's point about people on committees having more of a governmental email, is that something that we should do? Should we all have an fmb.gov type of email?
God, no.
Or is that something we have to set up on our own?
No.
We could, it requires us buying licenses for
Okay.
everybody, so I like the idea of you create your own.
Okay.
You know,
Not wanna
just-
do that? Okay.
You open up a second Gmail account,
Yeah.
Chris,
Okay.
AAC Chris at
Okay,
Gmail,
okay.
so everything comes into that one account for you.
I can barely manage my one Gmail account.
Okay, well, thank you, Amy. So the last question is, so you need to provide a copy of the records in a timely manner to
Amy.
Amy, correct. What about if you don't have a record? Do you have to create a record in response to a public records request? No, only what you have. Right. So what happens if you violate the public records law? So you've been, a person who has been denied the right to inspect or to view or copy the public records, they can bring a civil action against the agency, against the town, to enforce the terms of Chapter 119. So again, there's a distinction if you knowingly violate the provisions of the public records law, the penalty is much greater than if you inadvertently do it. So it's guilty of a misdemeanor of the first degree, possible criminal penalties of 1 year in prison, $100,000, or possibly both, and then voting conflicts. So anything else about public records that you guys have a burning question? If not, I'm gonna keep going. Yes, sir.
I hate to keep harping. So, in a committee meeting, you said, I'll gather this information, or I won't have this information until this period of time. But another member needs that information to create something. In other words, who are gonna be the sponsors for this event? Because we wanna put them on a poster to have at the event. I won't have that information until 4 to 8 hours before that event, I'll pass it on to you. Now, if I simply pass this on to them and they create the poster or whatever, have I violated passing it to them directly, or do I have to send it to?
I would send it to
Curtis.
Amy or Curtis,
Yeah.
Curtis
have
or
them send
Amy.
it back?
Yeah.
Okay. There would never be a situation where it'd be advised for me to physically drop it off.
No, I strongly discourage that.
Thank you.
Yeah. Okay, so voting conflicts. I have a form that I'm going to pass around to all of you. Hopefully, I have enough.
Here, we got a lot.
We good?
I got a lot more here, if anyone else.
Okay. All right. I think everybody has one.
Everybody has it.
So we're all looking at Form 8B, which is the memorandum of voting conflict for county, municipal, and other local public officers. It is 2 pages, and you can take this home with you. I'm going to be going over a lot of the information that's stated on the form, so we don't really need to read it together. But who does it apply to? Well, it applies to public officers. That means elected or appointed. So if you're a member of a collegial body, committee, board, commission, whatever, it's going to apply to you. So you cannot vote if you are elected or appointed. You should not be voting on anything that is going to go to your special private gain or loss, or anything that you know would go to the special private gain or loss of a principal, which is someone you're employed by, and you're going to see that in a moment, a parent organization, a relative, or a business associate. So who is a principal? A principal is an employer. It can be the client of a legal, accounting, insurance, or other professional practice. It can be a corporation for which the officer serves as a compensated director. Who is a relative? It's interesting that the definition of relative is different in the nepotism statute as well as in the gift law. But basically, the mother, son, daughter, husband, you can read those. Who's a business associate? This is a person or an entity that you're engaged in a business with, the public officer, regardless of the form of the business. So are the two of you, are you engaging in a common commercial or enterprise pursuit? And is it current, ongoing? Is it a current, ongoing business relationship? So just as in sunshine law and in public records, voting conflicts are not black and white. There's gray area. So just be careful as you proceed forward if you have a voting conflict. So special gain or loss has to be special. This requires some type of economic benefit or harm that's going to come to you or one of those individuals. And what should be considered, again, is the financial ramification of it. So if you are part of an affected class, what is the size? What is the relative benefit or harm when you compare it to other members of affected class? Is there a gain or loss that's remote or speculative? Is it merely preliminary or a procedural matter? So you're like, what is she talking about, right? Okay, so let me tell you what I'm talking about. Is let's say that you have a matter before you where you are required to vote, and it is affecting an organization that is a nonprofit, and it has 500 people in it, 100 people in it. So the size, that might be different as opposed to if it's an organization of maybe 20 people. So that's one thing that you need to balance. What is the benefit or the harm for you as opposed to those 19 other people, or you as opposed to the other 499 people? The actual benefit or the loss, is it somewhere into the future, or is it hard and a hard cost that you know is going to affect you? And is this just a preliminary type discussion? So again, it's not really black and white. So the special gain depends on the size of the class who are similarly affected. So the smaller the class, again, the 19 or the 20, the higher the chance of special gain. The larger the class, the less the chance of special gain. So is it remote or speculative? Before we get there, I want to go and say, if you're unsure, I err on the side of saying that there might be a special benefit. Because it's not going to be black and white. It's going to be a judgment call that you make. Is the gain or loss so remote or speculative that it cannot be said that it's going to impact your gain or loss? And this hinges on the fact of each case. So you can see the scale there. Even chance, what do you do there? Do you say yes or do you say no? Will you sleep at night? Do the right thing. I mean, those are the bottom line. Is it preliminary or procedural? Is this just something that's procedural, and then later on there would be an actual vote that would impact you financially? So again, sometimes, these are very broad guidelines. Sometimes it's procedural, but the procedure in effect has the substantive effect impacting your gain or loss. So what do you have to do? You need to abstain from voting. You need to disclose the conflict orally before the vote, and you need to file this Form 8B within 15 days. If you're appointed, you must publicly disclose the conflict before participating on the discussion of the matter. So the rules are a little bit different between elected and appointed members. So if the principal by whom you are retained is a public agency, you may vote. How does that work? I can tell you because I have a personal experience of that. So at one point in my life, I worked for Escambia County. I also served at the time on the Northwest Florida Water Management District. So I was an appointed member of the Water Management District. And you know what? They were giving out grants. And you know what? I wanted to take as much money back to Escambia County as I could. So did I have a conflict? No, because my employer was actually a public entity. So I tried to convince as many people as possible. I was semi-successful. If you're a commissioner of a community redevelopment agency, again, this one doesn't really apply to you. If it affects your expenses and your compensation as provided by law, you may vote. What do you think that refers to? Local officials, sometimes they have, they get a little salary or they get a stipend or something. And the only way that the entity can approve it is to have a vote, but you're voting for your own salary. So that is permitted. That is not a prohibited vote. So related issues, members of a collegial body to vote when present at a meeting prohibits abstaining, except when there is or appears to be a possible conflict of interest as provided by law. And the conflict of interests are those that are stated in the Form 8B. So if it is not a conflict under Form 8B, you have to vote. And sometimes some of these votes are very difficult, but you have to vote. The other exception that occurs that you would not have to vote would be in the context of a quasi-judicial proceeding. And this is where a member might abstain from voting if they just cannot be fair and free of potential bias or prejudice. Goes back to, I think, an earlier comment about you have to come to that meeting with an open mind. You have to listen to the testimony that's given and the documents that are presented. and nothing more. Okay. Florida Code of Ethics. I'm going to go very fast on these because I didn't really want to spend too much time. My goal with the Florida Code of Ethics is just to make you aware of them. So let's get started. So the prohibited conduct, and again, I mentioned the resource that I was going to use and leave you with is this, and this will give you a lot more information about each one of these items that I bring up. And some of them apply to state officers, which is not going to apply to you at all. But the solicitation or the acceptance of gifts, I think that the Anchorage Committee is very well aware of this one through their activities. And they basically went to, Chris, do you want to elaborate on your process for that?
Well, we determined that we could not have a raffle, but that we could ask for donation of gifts to be used for a drawing, and everyone is available to get a drawing ticket when they come to us.
And you asked town council
We
for
asked town
permission
council
to
for
do
permission
that.
to do this, yes, we
And
do.
any money that's received goes directly to the town.
Yes, goes directly to the town, it's made out to the town, they are keeping the bucket of money for us, and then they will pay for the meals that we use after the event is done.
Yes.
And
So
any
there's-
money that's left over will remain in our pot for future events.
Correct.
So, may I ask a question from my chair
Uh-huh.
in
Yes.
regards to that? So the bucket of donations that people put in
We will give to Curtis to bring to the
to
town.
bring to the town.
Yes, so we were allowed at the event to have cash donations, but we will not do anything with that. We're putting it into a lovely jar that Jennifer is providing, and we will give that to Curtis for deposit.
Okay. So this would be solicitation or acceptance of gifts. The acceptance of gifts gets a little tricky around the holiday season. The limit, again, I'm not really going into detail on this, but it's basically $25. So if someone were to give me something or I gave you something that's less than $25, it's not going to be viewed as a prohibited gift. Between 25 and 100, you have to report it if you're like a lobbying entity, and then over 100 is just outright prohibited. So do not accept gifts. Also, the solicitation component, it's tough because, you know, there are charities that maybe you might want to go and solicit for. However, if you come to me and you ask me for money and I know that you're sitting on BORCAB, you know, and maybe I need to influence BORCAB, I might give you money. That is discouraged, if not outright prohibited. Kind of that quid pro quo type scenario that you've heard of before.
Does that include gift cards? I mean, is that
Yeah.
considered gift cards and
Yes, yes, keep it under $25 and then you should be fine. So the unauthorized compensation, this is just something that is above and more. I'm trying to see if I can find the example. It's basically anything of value that you get in addition to any type of, I don't think you guys get compensation though, you know, on the board, so, so scratch that one. But let's go on to the misuse of public position. The one example of this that unfortunately it's a real situation where there was a tax collector in another county that was stopped by a police officer. And the first thing he did was, why are you stopping me? You know, and it's like, because you were speeding or whatever it was. But hey, I'm the tax collector. No, do not do that at all. Just because you have the privilege of occupying this position, you really should not and cannot use it to your own personal advantage. Kind of goes to the abuse of your position as well. You may come across some information that is being discussed at town council, even publicly, but may not be well known throughout the community. And so you seize upon that, but it's public information, yeah, but there's only a small group of people right now that know about it. So you can't do that. And that's the disclosure of certain information. And then again, the solicitation or the acceptance of honoraria. So, prohibited employment and business relationships, you can't do business with the town. I mean, can't really enter into that, but there's always an exception. And what the exception is basically if there is a rotation. And the example is, and it's actually a true situation, where there's an elected official who has a towing company, and a particular area has a rotation process for towing cars. And there's only like 5 people in the community that tow cars. And so that person, that elected official, is part of that rotation process, and that seems to be okay. Also, if you are, let's say you own property, and it's property that the town needs to acquire. So now you're gonna have to vote on purchasing that property. That is an exception because you would have a business relationship in the transaction of that and the purchase of that. Okay, the lobbying by state agencies, again, that's not applicable to us. Additional lobbying restrictions doesn't really apply. Employees holding office. I do know that some of you participate on more than one committee, and that is okay with town council. They vote to allow you to have participation. As far as public employees, it kind of goes the same way. This is saying holding office. Basically, you can't be an elected official and for one municipality and then be employed by the same one. That actually occurred in some of the smaller cities that had elected officials serving as town staff because they were understaffed. Professional occupational licensing board members doesn't apply to you. Contractual services, prohibited employment. This is the situation where maybe you have a business relationship with an entity that bids on town proposals that we have going out. That would be prohibited. The local government attorneys, that this means that if we were to have other private clients that did development work, that we would not come before the town, which we do not have any of those. We like to stay local government, so we never have to worry about a conflict or a possible ethics concern. The dual public employment, again, that is dual office holding, where you can't occupy more than one office. The anti-nepotism law with additional restrictions, that doesn't really apply to you. The revolving door, this really applies more at the state level. The only bottom one is the lobbying by former local government officers and employees. And this applies to elected officials. So, who is the Sunshine Police? Who enforces that?
The AG.
Okay, the AG provides good information about it, but the enforcer is state attorney, yes. What about the public records? Same thing, because remember, there's criminal penalties as well as civil penalties. So you might get sued civilly, but you might also be charged with an offense. So who do you think is going to be the watchdog of Florida ethics? Amy. She's very, very ethical. So it is the Florida Ethics Commission, and Carrie Stillman is the the executive director there. It is an entity in Tallahassee. That is their phone number. That is their website, and they have a volume of good information and resources that you can check out and delve into. Again, this is their most recent pamphlet that kind of describes some of the things I very quickly ran through. And that concludes my presentation. So, any more questions? We got a little bit of time, but
Is this
you
something
guys-
that we have to fill out?
you're going to hold on to that.
Okay.
And if you ever find yourself in a situation where on the second page, that something before you is going to go to your special benefit or gain, or the special benefit or gain of your business associate, your relative, your principal, then you would be filling this out. This is a good form to
I was
have.
just asking because I don't have my reading glasses.
Oh, okay.
Hey, Nancy?
Yes.
I don't know that if you covered it or not, but it's something that I was surprised to learn the rules around is what's called wheeling, where you go from one person to the next.
The conduit, is that the conduit that you're talking
I
about?
don't know if that's the terminology, but it's,
Wheeling?
I've heard it described as wheeling, where it's going and almost like pulling one person to the next.
But you couldn't do that as a, appointed, if it's, a local government type, if it's the matter before you, of course you would not. Okay, so I'm gonna tell you a story. So, what about, this is based off true facts, but it's still, I'm just gonna deviate from the facts as well. And then, afterwards, if you guys wanna go and get the real facts, that's fine too. But what about if you're sitting on a committee and you have a really controversial thing coming up, and your meeting is noticed, right? And so you know you're gonna take action at that meeting, and you get in your car, and then you get a text message that says, the town manager has canceled the meeting. And you show up at town hall, and there's some of your other committee members, and they're, you know, did you get the message? Yeah, he's canceling the meeting. Well, because why? You know, he or she didn't want us to discuss this. But you know what? I think the Bay Oaks Recreation area, I think it's open. Let's go have a meeting over there. So you guys walk over there, you go in, and you close the door. Well, there's some other people too. It's not just the committee members. There's maybe 5 or 10 people. So everybody walks over there because, hey, the meeting was noticed, right? But it was canceled, but who knows about the cancellation? So let's go have a meeting over there. So you walk in and you close the door, and you know what? The door locks. Oh my gosh. And then you know what else? Someone in the community saw a group of people with 2 or more members of a committee walking over there, and so they called law enforcement. And law enforcement went over there and knocked on, hey, what's going on? What's going on? What was going on was, and this was a city council that did this, they fired the city manager. They took a vote to fire the city manager in that room. They took a vote to fire the city attorney. And they took a vote to reappoint one of the 3 that were there to be the mayor.
Wow.
Pretty
And
productive.
there's the police, right? So, do you think that was a sunshine violation?
Yeah, absolutely.
Yes. And do
Never
you think
happened.
there were some criminal charges associated with that? Yes. And the community spoke out. This community actually went on a recall, and those 3 elected officials were recalled and no longer had their seat. So that happened. Another story, real quick. This is in a county, and newly elected person got on this, it's county commission, got on county commission, and didn't really get good onboarding. Wasn't quite sure what to do. And again, I'm kind of changing the facts a little bit, but it's the crux of the matter. And made calls to another commissioner, county commissioner, asking, well, what do I do? I don't know what to do. And then basically used his wife to ask the question, so he didn't have to ask the question. And down the road, they found out that this was going on, and he learned that it was not proper to do that. That was a violation. You shouldn't be doing that. So it was unknowing, right? So there were no criminal charges, but there was an investigation because, again, the public was concerned and went to the state attorney, right? They did an investigation. And then during the investigation, they made representations that any contact between the 2 of them stopped. Once they found out they weren't supposed to do it, it stopped. But unfortunately, during the investigation, telephone records were discovered. quite a number of telephone records. And you know what? Those telephone records showed that there was a conversation between two telephone numbers, like the day or two before a meeting, and then the day or two after a meeting. And ultimately, they both got in trouble. So I'll leave it at that. But I hope that those examples, it shows you that it can happen to anybody. So always kind of be on your toes and make sure that you understand. I am available for questions, but as far as ethics, I am not the Florida Ethics Commission, so I am just the opinion of one attorney. The same is true with public records and Sunshine. Again, I'm not the state attorney. However, coming to me and asking me questions, I think is evidence that there is not an intent to violate any of those 3 laws that I mentioned.
How many cases come forward every year?
For which type?
Sunshine violation.
It depends on the circuit. Usually the ones that come forward become very publicized. I don't have an exact number for you, but if you go to the Attorney General's website, they will have a listing of the circuit court cases where public records and sunshine issues have come up. So I could talk more, but it's late in the day. So with that said,
Can I
yes,
ask
one
you-
more question,
Well,
yes.
actually, just in private, it has nothing to do
Okay,
with
that's
something
fine, I'll
else.
be around.
Thanks.
Thank you all for